Okay, we're going to be discussing this envelope you're seeing here. This is dead bang hard evidence proof that attorneys are not your friend. This is from defense counsel in my Oakland case, and it got sent back, address the unknown, this, that, and the other, and they knew damn well who it was that was sending it. I did make a mistake there, by the way. I identified him as Larry initially because I looked at the business card quickly, and I remembered it wrong. His name is Darryl Stallworth. But if you want to write this guy at the address you see on your screen and ask him when he's going to start to do his job, that would be a really good thing to do. And hard evidence. And now offensively, we're going to have this unopened letter to present to the jury and say to them, this is what happened here when he was supposed to be helping my friend who was sitting in jail at the time for like 4 months at the time this letter was sent. And I had sent him emails 2 days prior to this, and he knew this letter was coming and still sent it back because they don't care about us. Couldn't care less. I mean, there's no such thing as a defense counsel anymore. They're not going to do what it is that they have a sworn duty to do, and it's about damn time all this crap stops already. What are we supposed to do here? Damn. And you can't. If you're going on your own, then they think you're there pro se as your own attorney. Most of these damn black hole bastards don't understand the difference between pro se and proprietary persona. And that's the difference, by the way. That's not a small difference here, because if you're pro se, you're a 14th Amendment citizen and they own your ass lock, stock, and barrel. If you're in their proprietary persona sui juris, you're one of the people that has ancestors that created this Constitution and all government to secure the blessings of liberty to ourselves and our posterity. And we tell these bastards what to do. I mean, think about this. State Bar Association is a government agency. Therefore, attorneys are agents of our agents. And they're treating us like crap. It's time for this to stop already. And this case may go a long way to doing it. And if you get involved with this too, and I'm inviting you to do that, send me an email at youwinincourt@gmail.com. I'll send you the same documents and a little bit improved version. I've been changing these things and editing them, not weekly, but very often, based on events in this Oakland case and further research. You can do the same thing, because they're not going to help you. Not in their best interest to do it, and that's not our problem, because we're not subject to their jurisdiction. Once that secret gets out, it's over. And not just in traffic courts either. Now you're looking at tax courts, family courts, with all this crap with visitation, support payments, this, that, and the other. There's a lot of different venues that are involved here. It's not just this criminal case or traffic courts. It's all of them, because they don't operate on the principles that we set down in 1776 and reaffirmed in 1787 with the Constitution. And if there are changes, that's my constant question. What changed? I don't see it, except for the 14th Amendment, and that doesn't exist. So they have nowhere to go. You start asking questions like that, it gets interesting in a hurry. And that's what we need to start doing. An addendum to my Oakland update that we just did, and the main point here is that, this idiot I talked to, Darryl Stallworth, and you're not doing your job out there in case you don't know it. And if you want to sue me for defamation of character, come get it. Beat the hell out of you doing that too. But the big deal is we have a right to assistance of counsel. Now, that doesn't come from the non-existent 14th War Amendment. This is the recent epiphany I had on this, because we have rights secured by all 6 articles of the Constitution. And we have no way to vindicate those rights, since they don't teach us a damn thing in their mandatory public education system. And even in law school these days they don't. So we don't have a clue about what we're doing there. And yet we should. Therefore, the right to assistance of counsel we have comes from those first 6 articles of amendment. They're the ones that we want our agent to represent and put into court. And they're the only agents that are going to get listened to, because as you may know in the recent video I did on this same case, denial of habeas corpus, the black old bastard flat out said that they had the power to dismiss any and all pro se documents submitted, or summarily strike them from the record if wrongfully filed. If that's the case, then these attorneys have the duty to do what it is we want under Articles 1 through 6 because they're bound by this Constitution and the laws enacted in accordance therewith. That's the right we want, and they won't do it. And in this case, with Stallworth not even able to do it, no comprehension of the simple ABCs, for crying out loud, and didn't care because they think they have immunity for every damn thing you do. You can't get them. And in civil rights actions, that's true unless you get a case so bad they have to make it look good. Like that recent mugging of this poor guy that got killed out here in an arrest for jaywalking when he got tased 7 times and had a heart attack and died. You know, strikingly similar to what happened to Eric Garner in New York City. And for the same reason, this is never going to see a jury either. But only rare cases like that. And then only financial penalties. I'm going to want a lot more than just that. Get people sanctioned, get them dismissed from their job if they're not going to do it. And think about this. If you go to trial and your attorney isn't going to do what you want him to do and are ordering him to do, why bother to have a trial? Why not have him just declare the guilty verdict and get it over with? And in some papers I'm going to be presenting later, I'm going to say if you do that, I'm going to contact the heirs of Joseph Vissarionovich Stalin and ask them if they want me to represent them in suing the American government for infringement on his patent on trials of that type. I'd be willing to do it. That's how bad this is. They're not going to do their job. What's the point? You have no shot there. They got a 98+% conviction rate, and especially in a case like this where they charge every damn felony in the book to try to get you to take a plea bargain and plead to your felony of choice, exactly what happened in this case. And the kid I'm helping out laughed at him in court, which is what I would have done. 2 years in jail, and he hasn't done a damn thing wrong, and they don't have jurisdiction on top of that. So that's the real point. If we have that right, and that's the only right they think we have, even though it comes under Gideon B. Wainwright, heaven help us, Miranda v. Arizona, but it's 14th Amendment. But that's not what we're saying here. We're saying that we created all of this government to ensure the blessings of liberty to ourselves and our posterity. That's what the right is really based on. That's why we beat them, and they have nowhere to go when you raise these kind of issues. Even Sensberg is going to get this one, if she's around when the case gets there. I mean, that's how elementary this is. So, and that's how important this Oakland case is. It isn't just one case. In theory, at least, I could clean out the entirety of the Santa Rita Hilton out there based on one case. Every inmate in there is going to walk. Whether that struck home with anybody over there, I don't know. But in plain fact, the matter is, if you didn't have counsel, the Supreme Court said, Arthur Senior B. Hamlin, just like I was telling the attorney the other day, you can look it up, 407 U.S. 25, page 40, let each judge know at the start of a misdemeanor trial, let alone felony, that no jail time can be imposed, though local law permits it when the accused was not represented at trial. Exactly the opposite of what they do. And the Supreme Court, I think, knew that when they said it. So if you don't have counsel, and you don't have one, even if you think you have one, if he isn't going to present your issues, no counsel, no jail. Why have the trial but for a strikingly different reason? They can't convict you of anything. That's where we need to start heading here, and the quicker we get there, the quicker we're going to change this system and help benefit it, especially for your children and your grandchildren, so they don't have to go through this nonsense. So that said, we'll see how this case comes out, but that's the kind of groundwork we're going to have, and a lot of leverage to get them to pay us off from keeping it from going public. And I may or may not consider that. We haven't got to that point yet. If they make it worth our while, and I get enough to take care of me for the rest of my life, and I can go on to other cases and do exactly the same thing, maybe in your case, then we're going to get them, and we're not going to take a payout without any changes in, in the way they do business and in writing. So they're bound by the deal. That's what it is I was put here to do, and I'm going to keep trying until my time runs out, whenever that may be. God help you bastards on the other side. Thank you.